It's a big year for the Supreme Court. In addition to taking on abortion and gun laws, this week the justices added another high-stakes case to its docket: racial preferences in college admissions. The court will jointly consider a pair of lawsuits filed by Students for Fair Admissions. The group argues that Harvard and the University of North Carolina discriminate against a minority group, Asian applicants. The decision could spell the end of affirmative action in the college admissions process. The High Court has considered the issue several times before since the late 1970s, and it's traditionally upheld the practice, but with limits. For example, racial quotas are not permitted, but it is okay to consider race a plus factor as long as it's not the defining factor. The justices also expected that preferential treatment wouldn't be needed forever. So how will they look at this issue in 2022? We're joined now by a man who has been in this battle for 3 decades, Ward Connerly, a former University of California Regent and the man who successfully led the campaign for Prop 209 in 1995, which bans the state of California from discriminating on the basis of race. He's also the founder and president of the American Civil Rights Institute. And in case anyone is unsure where he stands on this issue, his autobiography is titled "Creating Equal: My Fight Against Race Preferences." Ward Connerly, it is a real pleasure to have you on The Nation Speaks.
Cindy, the pleasure is mine.
So we probably have a good idea how you think the Supreme Court should rule on these cases, and we will get to that. But I'd like you to help us first understand how we got here, and if you think that affirmative action or race preference policies were ever a good idea.
You know, I wrestle with the whole question of whether it was a good idea or not, because we should have been able to foresee what would happen after we started it, but we did not. Let me just quickly tell you that I was born during the era of Jim Crow. There was a C on my birth certificate. That C was not for Connerly, it was for colored. And that meant that at birth, I was going to be outside the mainstream of American life. That was my assignment, according to Jim Crow. And something had to be done to change the culture, to make sure that people did not discriminate against people like me because of our skin color. And I can tell you, Cindy, that during that period, there was a direct correlation between that C on my birth certificate and how I was treated. There was a presumption of my inferiority. And so something needed to be done to change society. And affirmative action, which when President Kennedy signed it, affirmative action was intended to be an aggressive approach toward discrimination, toward racism. Lyndon Baines Johnson, however, changed it after President Kennedy was assassinated to produce goals and timetables and explicit race consciousness. And there was no need for that. That was not the way to go. In fact, President Kennedy had said, race has no place in American life or law. And so we created a system that was destined to become permanent, which it was not supposed to be, and one that became a system of preferring one person over another on the basis of race. Our thinking during that period about affirmative action was that nobody was harmed. This was simply readying Black people to participate in American life. It was just helping the people who were the intended beneficiaries with no harm or detriment to anybody else. Well, we now know that that is not what has happened. Affirmative action has become permanent. It is something that Black people believe they can't do without. I can't begin to tell you the abuse that I have suffered from Black people because I'm, quote, taking away something that they believe they've earned.
So what's interesting about comparing Kennedy and LBJ is that JFK's executive order established the President's Committee on Equal Employment Opportunity, in which it said that government contractors should take affirmative action to ensure that applicants and employees are treated without regard to their race, creed, color, or national origin. But then in 1965, his successor LBJ said that we should seek not just equality as a right and a theory, but equality as a fact and equality as a result. So the contrast then, it seems, is the same as what's at the heart of the debate now, equality of opportunity versus equality of outcome.
Bingo. Those of us who oppose race preferences want equal opportunity. That's what the founders envisioned, a system of competition in which the government would not pick winners and losers, but we would all have an equal chance to compete for jobs, for college admissions, for public contracts. But the competition is something that those who favor affirmative action really don't want. They want the outcome.
Is this what the Supreme Court will be focusing their attention on? What will they be looking at to decide these cases?
They, I hope, will be looking at the true words, the words that are embedded in the 14th Amendment to the Constitution. The problem they're going to have to wrestle with is the fact that they have created a body of precedents that are contradictory. In 78, justices were saying that the Constitution is colorblind, but in 2003, in the Grutter decision, the court opined that diversity was of compelling need, that diversity was a compelling state interest. Those two things are in conflict. And I don't know how the court is going to make the transition back to 78 in terms of their legal jurisprudence. But I think that they're just going to have to say, we made a mistake in 2003, and the Constitution is colorblind, and every individual is entitled to equal treatment under the law, period.
And in 2003, the court also said that it expected this would be a temporary measure. It said that in 25 years from now, it expects the use of racial preferences will no longer be necessary to further the interests approved today. So do you think that will play into it as well? Maybe that's a way to reconcile 1978 and 2003.
You may be right. I think that is a way. So I think that they're in a cul-de-sac in their thinking here.
Be sure to watch the entire episode, now available exclusively at epochtv.com, a new completely censorship-free premium subscription platform brought to you by the Epoch Times. See you there.